Okay, so what we're going to do today is we're going to do a quick review of all three of the strategies, okay? Of the MBE, which is the multiple choice, the MPT, which is the performance test, and the MEE, which is the essays. We're just going to do a quick review of the general ideas that you guys need to make sure you're keeping in mind when you're doing the strategies, okay?
Okay.
Now, what is important is that you guys understand that this is aside from the substantive law that you have to learn, right? And so this is about how you are able to deploy the knowledge that you're going to get from studying the rules, memorizing the rules, and doing practice questions, okay? So the first thing that I'm going to do is I'm going to walk you guys through the performance test, okay? So for the performance test, what do we know generally about it, right? It's two of them. You get 3 hours to do both of them. You should split them up into an hour and a half each, okay? The way that the performance test is set up, it's essentially a closed world. They give you a file that has everything. The file is going to have a task memo. It's going to have a law library that usually has statutes, cases, etc. And they're also going to have a facts section where you're going to grab all the facts that you're going to plug into to decide and advise on the task memo. Now, generally, you're going to write one of two ways. You're going to write objectively, which means that you're just conveying information. You're not taking a position. Or you're going to write persuasively, which means you're being asked in the sheet that tells you what to do, the task memo, you're going to be asked to take a specific position on issues and persuade accordingly. The main distinction between these two, and now these can manifest themselves in different ways. They could be write a persuasive letter, write a brief for trial. If it's objective, it could be write a contract, write a constitution. It doesn't matter, but the base level of what you need to do is the same. It's either going to be write objectively or write persuasively, okay? If you're writing objectively, what you want to make sure is that your headings are not conclusory in any kind of way, okay? So you don't want to argue a point in your headings, okay, if you're not asked to write persuasively. So what you want to do is essentially maybe answer the question that is being prompted, but you don't need to put any more emotion or convincing wording behind it. You just want to essentially tell the reader what your conclusion is based on the objective facts presented to you. Now, when you're doing a persuasive MPT, you want to do this in a different way. What you want to do is you want to go with essentially whatever the ultimate analysis is going to be, you want to reduce that to one sentence and you want to make that your heading, right? And here's where you want to make sure that you are being forceful and convincing. So if you believe that Tweety should be convicted, then what you want to convey in your heading is Tweety should be convicted because, and then you give a essentially one sentence synopsis of what you're going to include in the following section. But it's very important that if you're being asked to write persuasively, your heading sound like an argument. It sounds like you are making a conclusion based on the facts. Now, whether that conclusion is objectively correct or not, it does not matter, because what you're being tasked with is to argue persuasively. So while there may be other facts that tell you to do things a different way, or that the analysis might go a different way, if you're writing persuasively, your heading needs to have the strongest fact for the position that you're being asked to argue, and you need to consolidate it to one sentence and keep it organized in the order that you're analyzing issues, okay? So now that we have those kind of macros, the big picture items, the next thing, the order that you always want to go in is you always want to read the task memo, then you want to read the library, and then you want to read the facts section. The most important part of writing an MPT is writing an organized outline. If you have an organized outline, then the likelihood of you writing a good MPT is a lot higher. The challenge comes when you're being asked to write a good outline in 45 minutes because you only have 45 minutes to actually write out the MPT, okay? And so the way that you do that is you always want to read the task memo first, and what you want to extrapolate right away is what the issues are. Okay, what are you being asked to do? Okay, that's the biggest thing that you want to do. Give me a quick second and I'm going to pull up a task memo for you guys. Give me a second. Okay, can you guys see this memorandum of law that I'm sharing?
Yeah, I do.
Okay, so can you see it, Catrice?
Yes.
Okay, cool. So again, the task memo is usually going to come to you as a memorandum of law. It's usually going to be one page. I think here or there it might be a page and a half, but that's or two, but that it's by far and large going to be just one page. Okay, so what the memorandum of law is going to do, it's going to give you very clear instructions on what they expect you to do when you're writing your performance test. And while it's a lot of information, right? Even here, it's memorandum file. Well, this is more facts, but right here, everything that you need in order to ascertain what to do on the MPT is going to be here. Now, obviously, this is 3 paragraphs of information. You want to consolidate this to just a few words, right? Get your marching orders and go. So it's important to go through this and understand what exactly is required of you. So always look for a few things. Are you being asked to write objectively or persuasively? Second of all, what are they asking you to analyze? What are the legal issues? And third, is there anything else besides legal analysis that they're asking you to analyze? And I'm sorry, I guess a fourth thing would be, what kind of reader are you being asked to write to? Is it someone who has legal knowledge? Is it somebody who doesn't? Because graders will allocate points based on if you're giving a lot of legal language and they're asking you to send the letter to the client who has no legal expertise, you will be docked points. So here it says, last year, our client Daniel Harrison bought a 10-acre tract of land in the city of Abbeville from the federal government, which had used the property as an armory and vehicle storage facility. The tract is currently zoned for single-family residential development. Harrison applied for a rezoning of the property to use it as a truck driving facility, but the city denied the application. So right there, you already know what the issue is going to be. He got denied an application, right? So my guess would be is that he is seeking the legal advice to figure out how to get around this denial and what maybe the legal issues around that are. And we already know this is going to be a real estate zoning issue. So Harrison wants to know whether he can pursue an inverse condemnation case seeking compensation from the city based on the denial of his rezoning application. See, so now it's even narrower. We know what it is regarding the zoning. He wants a inverse condemnation, right? So that's the issue. That would be the first thing you would jot down in your outline is inverse condemnation issue. Now, there's going to be more things beyond that, but at least now we know what the client wants. And because he wants to know, then you can infer from that that you don't need to persuade the client. You need to just give them objective information. So there's a good chance that this is actually an objective memorandum that you're being asked to write. Okay, so inverse condemnation is a legal proceeding in which private property owner seeks compensation from governmental entity based on governmental entity's use or regulation of the owner's property. Okay, so now they're telling you what it is, but you guys should have a general idea anyway. Please draft a memorandum to me identifying each of the inverse condemnation theories available under Franklin and federal law and analyzing whether Harrison might succeed against the city under each of those theories. So now we've confirmed we're just writing a memorandum. It does not need to be persuasive. We're writing objectively. So you should put somewhere in your outline the word objective so that you remember. This now means that the headings do not need to be persuasive. They just need to state your conclusion or the issue that you're analyzing for each of the separate theories that you're being asked to analyze. Another key piece of evidence here is they're telling you analyze both Franklin law and federal law. So you would want to note that, right? And we know that there's a finite amount of theories. We just don't know how many yet. You're going to grab that from the law library. So let's see, note that there has been no physical taking, so do not address that issue. So you want to flag that in your outline. Do not address physical taking, right? If you do, you're going to lose time and points. Well, maybe not points actually you will, and you'll definitely lose time, which means you're going to lose more points. Do not prepare a separate statement of facts. They're almost always going to tell you not to prepare a separate statement of facts, but they're just going to ask you to incorporate them in your arguments. So do not make a separate fact section on MPTs ever, unless you are explicitly instructed to do so. Analyze all applicable legal authorities and explain how the facts and law affect your analysis. Okay, that's nothing new. They're just asking you to give an objective memorandum. So those are the things that we want to extrapolate from the memorandum, from the task memo. Okay, and that is, are we writing objectively or persuasively? Are we writing to a legally trained reader? Here, you're being asked to give this to your boss. So presumably your boss is also an attorney, and therefore you're writing to a legally trained reader. We know it's objective. And what are we being asked to analyze? We're being asked to analyze the theories of inverse condemnation under Franklin and federal law. And what are we not being asked to analyze is physical taking, because one has not occurred. What else are we being asked not to do? It's to write a separate fact section. Okay, so that is what you need to extrapolate from the task memo in when you're doing an MPT. Then after that, you're going, and we won't get into heavy detail today because there is another MPT lecture that you guys can review if you need a deep dive into it. But the main thing that you want to take away from this is that you need to grab very important information, and it's about 4 different things that need to happen from your task memo. If you are able to do that, then you will wind up at a minimum leading yourself down the correct path when you're doing the MPT. Then when you get into the law library, you want to make sure that you already know what you're looking for. You're looking for legal theories under federal and Franklin law for inverse condemnation. So anything that jumps out at you in the law library that speaks to that, you need to incorporate into your outline. Then once you get through the law library and you know what your theories are, you know that you're not analyzing physical taking, then you work your way back to the facts. And the way that the MPT file is lined up, you'll have the task memo, the facts, and then the law library. You want to go task memo, jump the facts, go straight to the law library. Okay, and then once you have all the theories, right, the theories are going to have elements, they're probably going to have tests or factors that need to be analyzed. Then you go back to the facts section and you incorporate the relevant facts very intentionally under each of the theories that they could apply. And even more so, if you can, under each of the elements or factors or tests that you are analyzing, okay? And so that's how you build your outline. Your outline gets built by what do I need to analyze and how do I need to analyze it? What in the law library am I specifically being asked to analyze? This is where you're pulling the law, okay? And then you go into the facts section, and what you're doing is you are grabbing the relevant facts, and you're not just putting them anywhere. You're very intentionally putting them into the specific theory that is being asked, that you're being asked to analyze. Now, if for whatever reason you need to recycle facts because you're analyzing the same facts for more than one theory, that's totally fine. But you still want to put them in each specific part of the outline. You don't want to just have your facts over here and all your law over here and a disconnect, because that means that when you're trying to write, you're not only going to write, you're also going to be trying to put together your rules with your relevant facts, and that's time consuming. Whereas if you do it in the beginning, there's a good chance that you're going to save that time down the road. Okay, so that's grabbing all of the information that you need in order to write the MPT. And so what you want to make sure that you're doing is that you're doing all of that within 45 minutes, right? And the way to do that within 45 minutes is to take no more than 2-3 minutes to read the task memo, jot down the important information we discussed. Then you go to the library section. You can spend probably about 15 minutes on this, okay? You're grabbing the relevant information, right? You're being asked to analyze theories on inverse condemnation. You're grabbing law around those. And if they're telling you theories, it means that there's more than one, which means you're going to have more than one heading, right? Because there's probably going to be one on partial taking, one on economic taking, and then you have federal, and then you have Franklin law as well. So that's the way you want to divide up your outline, the way that you're going to create your headings when you actually write the MPT. Then you're going to spend 15 minutes in the facts section. And this is where you're incorporating everything into the outline that you have with just law at this point. And then lastly, you want to make sure that you are taking about 12 minutes or so, 10 minutes to outline. Make sure your outline is tight, okay? Because the more organized your outline will be, the quicker it will be for you to actually write out the MPT in an organized way that ensures that you're picking up points, okay? But you got to work on doing this all in 45 minutes. For the remainder of the time that you guys have to study for the bar, whenever you do an MPT, you should be doing it in an hour and a half time constraint. There's really no value at this juncture in the study period to try and do an MPT with an unlimited amount of time or more time, because that's not the way you're going to be tested. And so you're doing yourself a disservice to try and prepare for it in that way. Okay, so are we clear on MPTs and how to approach them?
Yes.
Okay.
Yes.
If you guys need a deeper dive into it, go back into the Student Center in the welcome packet and look at the MPT strategies lecture, okay? If you guys feel like you need something more in depth or a larger refresher, okay? Now, as far as the next thing that we're going to discuss is the essays, okay? And I'm going in the order that things will be tested on the bar. First, you get tested for your MPT in the morning. Then the first day in the afternoon, you're doing essays. And then the second day, you're doing multiple choice questions, both morning and afternoon. For your essays, the main thing I want to discuss today, and again, if you guys need another deep dive, go into the videos in the welcome packet, is what you need to do in order to spot the issues, okay? And what you need to remember is do the funnel method, right? You want to make sure that you are eliminating rules that are not tested from the very beginning on the essays, okay? And the way that you do this in the issue spotting is first you read the calls of the question. So let me actually pull up an essay so we can go through this together. Give me a quick second. Okay, so obviously the practice questions that you get are going to tell you what subject is tested, but on the actual bar exam, they're not, right? And so you want to make sure that immediately when you're going into reading an essay, you're trying to nail down what subject is being tested. Now, there is a trend that tends to go towards essentially testing hybrids. Okay, that doesn't mean every essay is a hybrid, but I would say on average now about 2 of them out of the 6 are hybrids at a minimum. And so you want to look out for. But that being said, even if you can nail it down to 2 subjects out of the 15 that can be tested for the MBEs, then it's still a good use of your time, because now you're operating in a very finite amount of space, okay? So let's see. What you always want to do is you always want to read the calls of the question first, right? Even if you have to go back and refresh exactly what is being asked of you, but you definitely want to make sure that you're reading that first. So, and you're annotating as to whatever it is that you feel is important from the calls of the question. So here, question 1 is, did the buyer acquire title to the 3-acre tract or any portion of it? That immediately tells us what? That this is a property question, right? This is a real property question. They wouldn't be talking about acquisition of title to land in a criminal procedure question or in an evidence question, right? Or in a secure transactions question. And so now we know we're in potentially property essay, at a minimum property. If anything, it might be hybrid, it might be property plus something else, but property is a bit tough to merge with another subject. Maybe they can merge it with wills and trusts, or contracts, but you know, it's that's not the rule. That's the exception to the rule, even though it's trending more so towards hybrids. So that being said, did the buyer acquire title to the 3-acre tract or any portion of it? So very key thing to pull away here. Oh, this thing's actually doing it in white. So let me change this to red. Okay, so they're asking you to, again, with this thing being white, here we go. All right, give me a second here. Let's see. There we go. Now it's the right color. Perfect. Okay. So did the buyer acquired title. So they're asking you to analyze it as to the buyer, okay? It's always very important, especially in property questions, but certainly in every other one, such as evidence, torts, and even Compel, is you want to identify who the party that they're asking you to analyze for is, okay? Here it's the buyer. The next thing is acquired title to the 3-acre tract. So it's who, and then it's the what, right? And then any portion of it. So did he get the 3-acre tract or any portion? All right, so that's what they want to know. Now, let's narrow this down even more without even reading the facts. What do we know about how to do reducing the amount of potential rules that are being tested? There's a finite amount of ways in which a person can acquire title under real property law, right? It can be conveyed to them, they can buy it, and they can buy it and get it because they're a bona fide purchaser, because they're a subsequent purchaser. They can be conveyed the land in a will. They can get the land as a gift. They can get land in many different ways, which is in fee simple absolute, or as defeasible fees, or life estates, right? But there's no, or they can acquire it under adverse possession, okay? But there's no ways outside of those that I mentioned, plus maybe a couple more that I'm leaving out here or there, in which a person can acquire title, right? And so keep that in your mind as you're going through the essay. You don't want to go through the essay just thinking about every rule under the sun for acquisition of title, because there's a finite amount of ways in which a person can obtain title under real property law. And so you keep that in mind as you start reading the facts, okay? So that you understand that you need to keep going and reducing the amount of information in your head, so that when you're pulling out facts for the rules to apply in your IRAC, you're doing so in this closed universe, okay? So now the second question, assuming that the buyer did not acquire title, okay? So this is important because they're asking you to assume something. To the entire 3-acre tract, can the buyer recover damages from the sister who sold them the 3-acre tract? Okay, so this is damages, could arguably be a contract question, right? But what do we know? What can we ascertain from this second question? Well, first of all, they're kind of telling us, assume that he didn't get a 3-acre tract. This is it's kind of a pseudoscience, but it's a good way of thinking that when you analyze number one, there's a slight possibility that maybe the first thing will fail, okay? The 3-acre tract part will fail because they're telling you here to assume that he didn't acquire. So just keep an eye out when you're analyzing question one, if you felt that he did acquire a 3-acre tract. Now, if your analysis is very concise and positive, and you know that he did acquire a 3-acre tract, and the question two is just asking you to determine what if, then it's fine. But just always keep in mind, right? They don't tend to throw these things out at you without thinking it through. The next thing is it's telling you damages, right? So if they're asking you to analyze damages, it's very important for you to remember, what are the ways in which damages can be awarded? Well, generally it's monetary damages, right? But we know that in property, okay, in property, there's also specific performance, even though here they're not telling you to analyze specific performance, okay? So because they're telling you damages, I would say that you don't need to analyze specific performance, okay? Because they're literally telling you what money, if any, can you get. And then you know that you are there's a finite amount of ways in which a person can collect damages. It's general expectation damages. And if that theory fails, then you could look at restitution, you could look at unjust enrichment, quasi-contract theory, or promissory estoppel, okay, to see if someone is entitled to recover something, okay? But now, again, we're reducing from question one. We know that we are only in the land of how can someone acquire title to property, which is a finite amount of rules. Then in question two, we know we're in a finite amount of rules about how can someone recover damages when the sale of a property went wrong in some kind of way, okay? And then for the third question, assuming that the buyer acquired title to the entire 3-acre tract or a portion above the sewer line easement, okay, so right there, this is big, sewer line easement. There's a finite amount of ways in which an easement can exist, so keep that in mind. And also they're kind of giving you a head start on what facts you're going to get. You already know you're going to deal with acquisition of property, with damages, and now potentially with easements, okay? Can the buyer compel the sewer company to remove the sewer line under the garden? Okay, so now you know you're going to have not only an easement question, but you're also going to have a abatement of an easement question. And so that should trigger for you guys the doctrine in which the court will look at the economic feasibility of taking an easement out, okay? And so you want to think about the 4 ways in which an easement can be created, okay, which is by grant, by implication, by necessity, or by prescription, okay? And then the finite amount of ways in which an easement can be terminated, which could be by condemnation, it could be by abandonment, it could be by acquisition of the servient estate, okay? And there's the list goes on. But now we've taken from these 3 questions, okay, we went in thinking, what in the world could this essay be about, to reducing it to, it's about property, so we should only be thinking about property, maybe a touch of contracts there in question 2, but definitely now we've reduced from 15 subjects down to like 1 subject and maybe 1 topic on a 2nd subject. Then from question 1, we were able to reduce it to the rules only concerning acquisition of property, which is a small section of property law, which could be concerning what kind of property you acquired, the deed requirements to convey property, et cetera, et cetera. Number 2, we're in a finite land where we are discussing when we're discussing damages to the sale of a property that did not work out. And we know we're going to go down the line of expectation damages. Specific performance is probably not going to be tested because they're asking you for damages. And then the other quasi-contract theories that prevent someone from getting unjust enrichment, such as restitution, promissory estoppel, et cetera. And then for number 3, they're literally telling us the rule that is probably going to be tested, and it's the rules for easements, okay? And there's a finite amount of way in which those can happen, which is by prescription, by necessity, by implication, or by grant, okay? PING should be your acronym for that, right? PING. And so, and then lastly is what happens to an easement, or what can be done when an easement exists that maybe shouldn't, right? It's the economic theories behind utility of land, right? But we're constantly reducing the amount of information that we need to have in our mind ready to deploy on our answer. Does that make sense? Okay, so before we go over into the MBE part, just a reminder, if you guys need to shore up any of your MEE work, just go and check out the videos in the student center, okay? And there we break down everything as far as how to write it. Okay, so the MBE, this is the 2nd day of the test. This is the part that is tested both in the morning and in the afternoon, and it's 50% of the total grade, okay? So it's 100 questions in the morning, 100 questions in the afternoon, and you have to finish them in 3 hours each section. Then you get a little lunch break in between. A couple of not substantive notes, but to keep in mind for the MBE, you guys are going to be exhausted going into the 2nd day, okay? The first day is a lot of typing. It's just a lot of touch and go. There's a good chance you guys might have not slept well the night before the first day. Do what you got to do to get your mind right at the end of the first day in the evening. Have a good meal. Try to get yourself to bed, even if you're not actually sleeping. Just give yourself the rest that you need. Okay. If you guys feel like at some point during the multiple choice questions you guys are burning out or running out of steam, do what you got to do. Have a drink of water. Right. Everybody's back to testing in person now. So if you feel like you're falling asleep, scratch the palm of your hands hard, so that you can try and wake yourself up, okay? But then immediately recalibrate and get back to answering questions because you don't want time to become a factor. A couple of general notes. You want to keep a good pace throughout the MBE portion, okay? That does not mean that you fly through 10 questions and then you slow down a lot in the next 10. It means that you're keeping a nice, consistent pace. The best way to test your pace is to test it before the actual exam in smaller blocks. So if you know you're doing 100 questions in 3 hours, it means you got to do 50 in an hour and a half, right? Which means that see, if I was good at math, I wouldn't have gone to law school. So it's 45 minutes, 25 questions, right? So every 45 minutes, you should have about 25 MBE questions done. So when you're practicing closed book time MBEs, look for those internal times to be consistent with what you will need to achieve in the 3-hour block, okay? So keep that in mind, and this is the time in the study period where you want to make sure that your timing on the MBE questions is where it needs to be. If you did a block of MBE questions and you notice that you burnt out around question 70, then between now and test time, which is only 3 weeks, it's a lot of time, then try and build in a couple of 100 question sets, okay? So you kind of build your stamina up so you're not crashing around question 60 or 70 or whatever it may be, okay? It's just like getting ready for a race. You just have to do the work, okay? Now, that being said, some questions are going to take you a little longer, like property questions are very fact intensive, they're very long, but by far and large, you should be giving every question the same amount of time, okay? Another thing, if you get to a question and you read it once and it's a long fact pattern, or even if it isn't, but you read it once, you know you're coming up on your time that you're allocating for each question and you still don't understand it, you still don't understand what's going on, then you want to essentially just pick an answer and go. Because I've seen disproportionately so that the students, if you don't get what the answer will be by almost 2 minutes on the MBE question, your likelihood of actually understanding what the question is and getting the answer correct drops exponentially. And so if you're going to just play a numbers game, every question is worth 1 point. There's no point and there's no reason to spend 3-4 minutes on a question that you already, when you're past that 2-minute threshold, your likelihood of getting it correct is a lot lower. What you want to do is just pick one, pick an answer and go, right? Because there's inevitably going to be another question coming up that is very easy for you to get correct and move on from. So you'll make up the points, right? Remember that I missed 50 questions on the MBE out of the 200 and still scored a very high score, way higher than what I needed to in order to pass. So you can miss 60 questions, 65 questions, depending on the state, and still pass the MBE portion. That is a lot of questions that you can get wrong. So I say that to say, do not spend more than 2 minutes on a question, because the statistics are very clear. You're not likely to get it right, and it's likely to just make you go on a roll where you start missing question after question, because now you're scrambling to catch up and essentially get back on the horse. And lastly, the students have a tendency to miss in streaks. If you guys go back to large sections of MBE question tests that you've done, you're going to see that you miss 4 in a row, 5 in a row. Some people, you miss 10 in a row. Then you get back on the horse, right? And overall, your scores will be fine, but the missing will happen in streaks. A lot of times, if you think back to when you missed in that streak, you'll remember something was happening. You felt kind of funky at the beginning of that streak. It kind of it got you out of whack. You didn't really know what to do, right? If that happens, take 30 seconds and reset, okay? There is a method to going through MBE questions, and maybe you just kind of lost your way, right? You were sprinting and you kind of stumbled, but you didn't fall down. So just slow down, get your feet under you, and then restart. Because what can happen when you do that is you kind of hit the reset button, and all of a sudden this, and again, it has to happen in 30 seconds. It can't be a 10-minute meditation session, right? In those 30 seconds, what happens is that you are essentially going through and hitting the reset. And so instead of missing 10 in a row, you might miss 4 in a row. And that will make a huge difference, because it'll give you back 3-4 points here and there. Okay. So just keep that in mind. That'll help. Now, let's just go over generally how I want you to approach the MBE questions. Okay. We're just going to talk about this. We don't actually need to show something because it doesn't, you guys have plenty of MBE questions to practice with. In our welcome packet, you have all the licensed one, the NCBE questions. So Make sure you just go through it, attack the subject that you're struggling with, be very intentional, okay? So generally you want to start with reading the call of the question, because a lot of times that is going to tell you what subject is being tested. Now, sometimes it won't. It'll just tell you who should the court hold for, and you won't know until you're reading the fact pattern. But at a minimum, it will tell you what it is that you need to go through in order to determine what exactly you need to do, okay? So if you see, for example, should the motion be suppressed? That is a telltale sign that you have a crim pro question. Should the evidence be admitted? It's a telltale sign that it's an evidence question. Is it constitutional? Con law, right? Who's entitled to the property? It's obviously a property question. If it tells you who should the court hold for, and you see that the fact pattern is extremely long, there's a good question. There's a good chance that that is a property question. Okay. How should the court rule? Property questions. Towards questions, etc. Now that you've done that, you get a general idea of what subject you're in. So do the same thing that I'm asking you to do in your essays, which is now reduce the amount of information that you are processing in your head as you're reading the fact pattern to only, okay, I'm only in evidence land. I'm only in criminal procedure land. I'm only in property land, right? And that'll help you reduce the amount of information that you need to process very quickly, okay? When you're reading the fact pattern, sometimes the fact pattern will start talking about a will. They'll start talking about a trust. Well, what do you know about wills and trusts? It's not tested on the MBE. So it's not going to be, even if the whole fact pattern feels like it's about a will, then you know that probably what they're testing you on is a property rule, not a wills and trust rule, because wills and trust is not tested on the MBE portion of the bar exam. So that's one way that will try to trick you. Something to keep in mind for the MBE that might not be true for the essay portion is to think about essentially you might have facts in an essay that are not as conducive to getting the right answer right. They might be just red herrings. That's a lot less likely to happen on the MBE, okay? If the fact is there, it's there for a reason on the MBE. Now, that being said, you want to go through, and as you're reading the fact pattern, you want to continue to reduce. So now you know what subject you're in. Then next, you want to ask yourself, what is the rule that is being tested, okay? And something else to keep in mind about the MBEs, the essays are going to test you on a more broad level, right? They're going to say, okay, what is the general doctrine of personal jurisdiction? Well, you got to tell them what traditional basis is, maybe what minimum contacts is, depending on what type of question, but it's more broad in that sense. On the MBE, a lot of times what they're testing is, do you know the exception to the rule, right? So if you're getting a personal jurisdiction question on an MBE, instead of, does the court have personal jurisdiction under traditional basis, and you're hitting the big points, it'll be something like, does the court have personal jurisdiction? But what they're really testing is, when is a corporation domiciled in a state? And what you need to know is that it's domiciled in a place of incorporation and in the place where the nerve center lies, right? Where the officers sit and make the decisions. And so the MBE questions are going to test the rules on a more granular level. They're going to test exceptions a lot more frequently, right? And so keep that in mind as you're going through the MBEs, right? If you feel like you got a really big picture question, there's a few gimmies there, right? There's a few questions that are very easy, but by far and large, they're really testing a very specific element or a very specific exception to a rule in the MBE. So keep that in mind, right? Always go through the rule. Once you've identified what rule is being tested, go through it in your mind very quickly. Okay, what is the actual rule? What are the exceptions to the rule? And then apply that to the facts, okay? Now, what I always tell you guys is that I want you to decide what your answer is before you ever look at an answer choice. The only exception to this is if the call of the question tells you which one is the best argument, or what is the most likely reason why, or anything that it gives you language that is comparative. When you get language like that in the call of the question, then the correct answer is actually going to be contingent on how bad the other answer choices are, right? Not on actually, is it the best answer, right? I'm sorry, it's not the correct answer, it's the best answer. But by far and large, that's not the question, the type of calls of the question that you have. So once you read the call of the question and the fact pattern, you should know exactly what your answer is going to be, right? And then what you're looking for is an answer choice that reflects your reasoning. Now, the answer choice will rarely be exactly verbatim what you were thinking the right answer to be, but it will touch on the correct concept that you were already thinking about, okay? And so you're looking for answer choices that will confirm your theory, okay? You're going to try and avoid as much as possible going into the answer choices thinking, what in the world could be tested here, right? And what in the world could the right answer be, okay? You're just looking for confirmation in the answer choices. You're not looking for the actual answer in the answer choice, okay? So that being said, a few general notes to keep in mind about your answer choices, which are traditionally the wrong answer choice. You're gonna have answer choices that give you the correct outcome. So they'll tell you yes, comma, no, comma, for the plaintiff, comma, for the defendant, comma, but they'll give you the wrong explanation, right? Typically you get 2 and 2 of the answer choices. 2 will say yes, comma, no, comma, right? And so you can immediately reduce it down to just 2 potential answer choices that could be correct. The wrong answer choice will generally misstate the law. How can you misstate the law? Well, it changes a word that changes the legal meaning. So for example, if the standard is reasonable duty of care, the wrong answer choice will say something like the exigent duty of care. Well, you know, from having read all of your torts outlines, that is not a legal standard in torts, right? And so you can immediately dispel that as the wrong answer choice. Another way that the wrong answer choice will be wrong is it'll give you an absolute statement of law. What I mean by that is it'll say yes, because the seller always has the duty to do their due diligence when purchasing a property, right? Well, first of all, that's wrong. Generally, under caveat emptor, it's the buyer. But even under those, there's exceptions, right? Like you can't have a material misrepresentation. You can't have a misrepresentation by omission. So what do you know? What do you gather from that? Is that there's generally no absolutes in law, right? For every rule that you guys have read, you've read exceptions to that rule. And so any answer choice that tells you yes, because so-and-so must all the time have to do this, then that is a good sign that that answer choice is wrong, right? I would say more than 90% of the time that's going to be wrong because there are no absolutes in law. There's always exceptions to the rule, okay? And lastly, I think another reason why an answer choice could potentially be incorrect is because it will tell you the correct answer. I'm sorry, it will tell you the correct law, but it will give you the wrong conclusion. So this is where you know that the answer is yes, comma, but this one will tell you no, comma, but it'll give you the exact rule that you are looking for as confirmation, right? So what they're essentially doing is they're taking the correct rule, they're just literally applying it incorrectly. And you need to be aware of that and look for that. That's how the wrong answer choice will be wrong, okay? And a lot of times you guys will get the question correct, not because the correct answer just jumped out at you and it was like, this has to be the right answer. It's because every other answer choice must be wrong for whatever reason, okay? So that's how I want you guys to approach the MBE questions. Don't look for a silver bullet in your answer choices. Just look for a clear reason why all 3 of the other answer choices are incorrect, okay? And then look for confirmation that the answer choice, that the legal conclusion you've determined is confirmed by the correct answer choice, and then be wary of how the wrong answer can be wrong based on all the things that, all the ways that I just mentioned. Okay, does that make sense for everyone?
Yes.
Yes.
Okay, good.